Good afternoon, everyone. This is Gabriela Munoz here at BCCDC. We're going to officially get started in just one more minute. We have a large class, so I'm just allowing everyone to log in officially and settle in. So one more minute. All right, guys, welcome again to our estate planning workshop. My name is Gabby Munoz here at BCCDC. We're going to officially get started because we have a really great class jam-packed with information for you guys. Before we officially get started, though, I want to go through some housekeeping items. So the class is going to take us for about an hour and a half until about 7:30. Again, it's going to be a lot of information that we're going to be covering, so definitely take your notes, submit your questions through the chat, and you'll be able to see it through your control panel. So if you're on a desktop or computer, your control panel will look just like the picture there to the right, and you're able to submit your questions there through the chat. If you're on a mobile device, tablet, or a phone, you should see a toolbar either at the bottom or top of your screen that has a little chat bubble, and you can send your questions through there. We will be answering those questions at the end of our session. I'll be here to go through them all and ask our guest speaker. There is a copy of today's presentation under our handout section. So again, if you're on a desktop computer, you should be able to see them there following that green arrow. And there's one handout there. And it's a copy of today's presentation. You can save it onto your computer if you're on a mobile device. Again, that toolbar, either in the top or bottom of the screen, has 3 little dots. You'll want to click that to actually get into the handout section where, again, you can download it. If you're on a mobile device that doesn't allow you to actually save for some reason the handout, you can always contact us and we can send it out to you. So not to worry. So again, putting a face to this voice, my name is Gabriela Munoz. I am one of the HUD counselors here at BCCDC. Our primary focus here is with meeting with families in different financial concerns, whether it's trying to purchase, maybe they're already homeowners, trying to refinance or facing some difficulties, or our home buyer education class. So our definite focus is revolving around the housing in general, whether starting off and buying or already homeowners and everything in between. Our focus here at BCCDC is to empower individuals and families by building wealth through education and homeownership. Our focus is with low to moderate income clients, but anyone is able to take advantage of these services, of these workshops. So like I mentioned, we do have various workshops. In addition to our HomeSmart series, which this is our first of 2022, we usually on a monthly basis have a different topic to share with you guys. Some of them are, for example, estate planning. Anyone can start estate planning, whether you're a homeowner or not. It's always good to start thinking of this. We also have classes on home maintenance, credit one-on-one, home preservation options. So definitely make sure to follow us on our Instagram, our Facebook, our newsletter to get what is the next topic coming up. And then we also have the home buyer workshop for those that are trying to purchase, might not really know what the process is. That class is great to kind of give you a full overview of what exactly does buying entail. We also offer coaching services, and again, revolving around the homeownership side. If we're trying to purchase, not really sure where we particularly are, We have our coaching for homeownership, where we sit with you, review your personal finances to figure out where you are, and from there create an action plan to get you to be mortgage ready. We also offer services for homeowners, whether again trying to refinance or maybe facing some financial difficulties. We try to cover it all. And then we also have a lending team here who's in charge of our first mortgage financing, down payment assistance, and the refinances for homeowners. So just to give you a little look into our upcoming workshops, we have on our home buyer course, we have a one coming up March 5th. It is a lengthy class, 9 to 2:30, but it goes through the whole process of purchasing. Our Spanish class is April 2nd. And this is a certified class. So you will be getting a certificate that's normally required for down payment assistances, first-time homebuyer loans that request this specific HUD approved certificate from you. So taking the class once, usually it's valid for a year. So I'd like to introduce our guest speaker, Roy Schneider with Schneider and Associates. He has served Ventura County for many, many years, been a partner here at BCCDC for very many years as well. His areas of expertise are in business planning, entity formation, mergers, acquisitions, and sales of businesses, employment laws, contracts, transaction matters, real estate, homeowner association, and then as today's topic, estate planning. So when assisting clients with that estate planning, he definitely makes sure to strategize with individuals, the family, and businesses to protect the family wealth and legacy. So that's really important in those planning tools to fit their particular needs. It's going to include reviewing their unique circumstances because everyone is definitely different, applying those different planning techniques such as trust, wills, powers of attorney, life insurance, all that jazz. So Roy, I know that you're on here, and I'm gonna actually switch over to your screen. So you should see that pop up that would allow you to share.
Okay, can you see the slides?
We can see the slides, and I can hear you perfectly fine. I'd like to take it away.
Perfectly. Okay. Thank you so much, Gabby.
Thank
Well,
you.
welcome everybody. Thank you for joining us this evening. As Gabby indicated, estate planning may sound spooky and scary and big. It really is not once it can be explained, and it is for everybody, especially if you have significant others, spouses, children, parents you're concerned about, a house you're going to be buying. Estate planning is going to make a big difference. You own a business, it's just something to consider for everybody at every age. So we're going to cover a lot, and I asked for an hour and a half. We may not go that whole time, so we'll have more time for questions. But I want to make sure we cover it. It's going to be difficult to absorb it all because it's a lot, but we do have the handouts, which is this presentation. So what you miss, you can go back and look again on the PowerPoint slides, and feel free to email me, email our office, call our office. If you want an appointment, if you're interested in estate planning, we have a whole estate planning questionnaire we send to you. You fill it out. You come talk to us at no charge. We tell you what you think would be best and the cost. Because we believe so much in people planning for their estates and protecting their families. So we begin with, what is estate planning? Well, it's a lot. It's planning for transfer of your estate to others during your lifetime, at death, after death. Also planning for incapacity. You may be young, you may be not thinking about death at this point, but anybody can get hit by a car, can get sick, and somebody has to take care of things for you if you can't, even if it's just temporary. So it involves all these kinds of plans. What is your estate? So you'll know. Well, it's everything that will pass to others as a result of your death. So it'll be your real estate, life insurance, retirement plans, bank accounts, cars, boats, your household furnishings, personal effects, all kinds of things, especially your internet stuff and your digital information. All these are things to think about that are past. And your business, if any of you have a business, where's that going to go? So your estate includes everything you own. Okay, so what does planning mean? Well, planning is for possible incapacity while you're alive. Who will handle your financial affairs? You're incapacitated, you're in an accident, you get an illness, you can't run your business, you can't pay your bills. Who's going to do that for you? You got to pay the rent, you got things to do. Who's going to do that? Who's going to provide for your physical needs? Who's going to take you to the doctors and make sure you get your medicines and do all those kind of things? And who will make the healthcare decisions for you if you can't? Those are kind of important planning for incapacity. At your death, the planning is who is to receive your estate? Who's going to get it? What portion? We'll talk about that. What portion? If you have children, if they don't all get equally, there's going to be family strife. That is such an interesting thing to talk about with people. Actually, family dynamics, which we'll get to, is actually more important than who gets what, when, or where. We'll have situations where a parent says, I've given my daughter $200,000 over the last 20 years because she needs money. My son's independent, never asked for money. He's on his own. So I'm going to give him $200,000 more on my death. Though your children will never speak to each other again. It's just those things. We'll talk more about that. Specific items. You may want, your daughter to get grandma's wedding ring or your son to get your fishing stuff. You can spell that out. That may be important. Otherwise, it's up for grabs. Outright distribution. Do your beneficiaries, are they going to get the assets outright? If you're going to own a home or you have life insurance or you've got some retirement benefits, there's real assets there. And what age do you want these people to get it? If you give it to them outright, well, they can't get it until they're at least 18. But if they do get your assets, think about it. At 18, they'll be broke at 19. That's just how it goes. So you want to think about spreading it out. And those are the kind of things we work with you. Your estate plan is a great time to think about your charitable religious bequests. A few $1,000s won't mean a whole lot to your beneficiaries, perhaps, but it'll mean a whole lot to your charity that you might like. So it's good to think about that. Disabled relative. You might have a child or a relative you'd like to help out who's receiving government assistance, SSI, or I think Medicaid, and they can't get too much. So we can create special trusts that can help them without losing their government benefits. Also, you will see how you can protect children from prior marriages. Today, people are on their second, third, fourth, fifth marriages. They got kids from this one and that one. Maybe you want to protect children from prior marriages. You can do that with an estate plan. Avoid probate. That's a big one. You do not want to have a probate. We'll talk about why. And eliminate estate taxes. Today, estate tax limit, it's so high before there's an estate tax, it doesn't affect very many people, but you would like to eliminate that possibility. Okay, so can you do any of this stuff? Yes, if you have a plan, and no if you don't. That's simple. If you have no estate plan at all, and something happens to you, it's a burden on your loved ones. Somebody's got to take care of this stuff if you don't. One thing that you may have to have if you're incapacitated and no one can sign for you, you've got nobody authorized to do that, you may have to have a conservatorship. A conservatorship is timely, it's expensive, it's a court proceeding. The judge is going to look at you and see if you're capable. You're going to be examined by social workers. It's really nothing you want to go through. And you can do a plan to avoid this. And also, if you don't have a trust or a will, you haven't got payable on death accounts, you haven't designated where everything goes, the state of California has created a will for you. It says where your stuff goes. And that may not be what you want. You don't want that. If you don't have proper planning, you may end up having a probate, and that's very expensive and time consuming, which we'll see. Okay, so obviously, we recommend that you plan your estate. And here's the tools that we do. That may seem overwhelming, but it really isn't. The tools, we have wills, trusts, durable powers of attorney, healthcare directives, your retirement pension plans, make sure proper beneficiary designations. It is interesting how many people we see who has a retirement plan, and I'll say, well, who's the beneficiary? And they go back and look, it was their, ex-wife from 3 times ago, and that's not what you want, so you want to check that out. Family dynamics, and who's going to be handling the financial matters. If you can't or you pass away, big deal. You should review your estate plan often, every 3 to 5 years, or if there's a major change, you've got more children, grandchildren, somebody in the family you want to benefit, it's time to kind of update these things. And it's not hard to update, and it's not all that expensive to update at all. We'll see. So here's one of the basic things that estate planning needs. And we recommend all this stuff, but if you had to have some, this is a very important one. Durable power of attorney. It's a special kind of power of attorney authorized by statute. And it's an exception to the general rule. The general rule is if you give somebody a power of attorney, that means they can sign your name on certain documents. It expires if you become incapacitated. Expires, no longer any good. The special durable power of attorney is made to continue and often doesn't take effect until you become incapacitated. And it does expire on death. Once the person dies, the power of attorney is useless. But it's very useful if you become incapacitated and somebody has to get into your bank account and pay your bills and maybe even run your business. Okay, so these power of attorneys are used to do a few things upon your incapacity. Manage your property and financial matters, your health care, and your personal care. Various uses for these powers of attorney. So for the management of your property and personal affairs, this is in the probate code here. We also have the Advanced Healthcare Directive under the probate code. You may have heard of the Advanced Healthcare Directive. Sometimes people call them living wills, but they handle, they give somebody authority to make healthcare decisions for you if you can't. So for your property affairs, you make somebody your agent, and it can be effective immediately or on incapacity. Ordinarily, if they're spouses, they make it effective immediately so that either spouse can sign the other's name if they wish. One's going to travel a lot, not be around. They want to make sure something can be signed. Normally, if it's other people, such as the children or friends or other relatives, oftentimes we recommend making it effective only on incapacity. So you don't have to worry about, somebody signing your name while you're perfectly well and able to do so. But it's important. And that gives some thought. Here's the stuff they do. They can buy, sell real estate. They can insure your real estate. They can do repairs. They can buy and sell and insure your personal property like cars. They can handle your investments, bank accounts, business interests. They can sell your business. So the agent under the power of attorney can do a lot if you're given that authority in the document. Also, they can do insurance, they can borrow on insurance, they can make decisions with regard to your retirement plan, your trust and estate benefits. They can even establish trusts for you if you haven't done one, which is a good thing. And if there's litigation, they can defend it, they can initiate it, and they can deal with the IRS. So it's quite significant. Also can provide where you're going to live, food, clothing, domestic help, deal with your pets, gifts. You may have a habit of making gifts all the time. You become incapacitated. Your agent can continue with those gifts. Also deal with the government. And the power of attorney also does nominate a conservator if you need one. Normally, though, with the documents we prepare, you never need one of those. The healthcare directive is usually effective only on incapacity. So as long as you're capable of making your own health decisions, yes. Nobody gets a second opinion on that. You get to make all the decisions. But you appoint an agent to deal with matters when you can't. So you have a healthcare directive. And in this healthcare directive, we combine the power of attorney for healthcare, your healthcare instructions, and your personal care instructions. So it's all one document that covers a lot of stuff dealing with your healthcare and who's going to be your agents. It's either a spouse or it's children, and so on. So it authorizes the agent to make healthcare decisions regarding treatment, services, procedures, diagnosis. If you can't, somebody has to be able to make the decision. Should they have that operation? Not. Should they have that kind of medicine or not? Somebody has to make the decisions. And also to end of life decisions. Many of, we have certain thoughts and wishes regarding end of life, either to be plugged in and artificially fed for as long as possible, or withdraw artificial nutrition, hydration, and other forms of health care just to keep you alive if you're no longer functioning and you're basically brain dead. And this is a decision that you make, and it's an important one. Certain religious people have certain directives from their churches or other institutions that say how things should be handled at this time. So basically, you also make decisions of where you're going to live to, providing meals. They work with the power of attorney and financial to help with this stuff. And a big one is medical records. Right now, you could be married, and if you go to the doctor, let's say you go to your spouse's doctor alone and say, my spouse is acting a little strange, I want to talk to you, that doctor should not and probably won't talk to you because of confidentiality. But if you have a healthcare directive, you're the agent, then the doctors will talk to you. And you can look at medical records, and you can get releases. You can get second opinions. So that's why it's important. Also, this healthcare directive, you get to choose whether you want to make any anatomical gifts. Anything, is good, or just the eyes, or just certain parts, or not at all. You get to make that decision. Also, the person who is your agent under the healthcare directive gets to make the funeral and burial arrangements if you haven't done that. So if you've done it in advance, you spell it out, and that's what's going to be honored. If not, then the person under the power of attorney for healthcare, they get to decide. They decide where to be buried, whether it's cremation or whatever. So it's a big responsibility. And that's why when you have like children, you have your spouse perhaps, and if you have children, 2 or 3, we often recommend that all of them be the agent for the healthcare, as opposed to just having one, because it's a lot of responsibility for that one child to decide whether or not to pull the plug on mom and dad. And that's why we recommend oftentimes that they all do it if they can. Also, the disposition of your remains. You want to donate your body for science or whatever you wish to do. You want to be spread out over the ocean, you can do that. Also, autopsy. You can authorize an autopsy. And this document complies with the medical privacy laws of HIPAA. So it meets all those tests. You got your end of life decisions I talked about. You want to be free of pain. You don't want to be just artificially kept alive. We have some people that do. They want to be hanging in there until they cure death. But that's not most people. They say, if my brain's gone and I'm just there, they can stop feeding me. Any other wishes you want, and adherence to your religious requirements. It's an important document. Also, you can specify where you want to live. I want to live at home as long as possible. You get a chance to say that. I want to stay socially active. I want to maintain my church affiliation. I want to have the clergy come by and see me from time to time. I want to go to church. I want to be outdoors. Here's your chance to kind of spell out how you want to be if you really are dependent on somebody and aren't able to handle everything by yourself. Okay, so the other type of document in the estate planning process are wills. Now, what's a will? A will is a legally binding instrument that governs the disposition of your estate. Oh, that's a mic. Okay, so the will is revocable. The person who makes the will is called a testator. That's the will, and it's in writing, and it's only effective until at the time of death, which means it can be revoked and changed at any time. And a will also is useful for designating guardians. If you have a minor child or children, you can designate a guardian in your will. But it really does not come into effect until you pass away. Okay, so the disadvantages of a will alone is it doesn't affect until death, no help during incapacity. So you become incapacitated, the will does no good. And the will must be probated unless everything goes to a surviving spouse. But even without another instrument like a trust, the surviving spouse still has to file something with the courts. It's relatively easy, but it still is a little bit of a court process. But without the spouse, if you have real estate worth more than $50,000, which who doesn't, if you have real estate, and your total estate is under $166,600, or if it's over that, you have to have a probate. So really, if you have a $50,000 in the bank and that's all you have, there's a very simplified procedure. You don't need a probate. But if your total estate is more than $166,600, or you got real estate with more than $50,000, you will have to have a probate. Also, wills are generally outright distributions. So your kids at 18 will just get it. It's outright. Whether maybe they have issues, maybe they're gambling, maybe they have alcohol, drug issues, you'd rather not give it to them right away, You don't have a choice unless you put a trust in your will. And that's called a testamentary trust, which is inside your will. Still, we don't recommend it because you still need a probate. You have no benefits until you die. So you've heard me talk about probates. What are the pros and cons of probate? Not much in the way of pros. The only pro really is you get judicial supervision of the estate. So if you don't really trust the people who you named to be your executors and handle things, a court will supervise them. They may be required to post a bond, and everything's going to be administered exactly the way it's supposed to be. But that's the only advantage. The disadvantages are huge. One is it's a delay. The average probate will take up to a year or longer. That means nothing can be given out to people. It's all held up for a year or longer. And probate is a court process. Our courts were actually closed for months. They were closed for months initially when COVID struck. And during the Omicron surge, it was closed. So everybody was pushed off. Nobody could do anything. You can imagine in judicial matters, the procedural complexity. You can't do it yourself. You have to have a lawyer do it. You just can't do it. It's not too complicated. There's a loss of privacy. Wills and probates, they're public. So everybody who wants to check and find out exactly what you had, who's getting what, and if you've got some substantial money, leaving it to your kids, they will get calls from the Ferrari salesman very quickly. So it's public, not what you want. And even worse, assets that you have, if you had to go on Medi-Cal, even your house, which is normally exempt while you're alive, can be subject to claims by Medi-Cal. There's a way to avoid that, we'll learn, but assets can be subject to claims by Medi-Cal. So probate's not the best. Plus, it's expensive. These are the fees. These fees haven't changed in 40 years. And 40 years ago, $100,000 was a lot of money. It's not that much anymore. So this is the amount that you pay. It's statutory. It's not negotiable. There's statutory fees, and the attorney and the executor each get fees. So this is all doubled. So just to give you an idea, the fees would be $66,000 for a $2 million estate and $46,000 for $1 million and so on. Plus, there's additional fees for extraordinary services. If the executor has to sell the home or sell a business or sell things, they get extra money for that. So as you can see, it is a costly process, time-consuming, costly, loss of privacy. Medi-Cal can grab what you have. It's nothing anybody really wants to happen. So how do you avoid it? Well, that's what you do. You try to limit your estate to non-probate. You can limit the estate to non-probate assets. That's one. So you can have property owned joint tenancy or community property with right of survivorship. Whether it's real estate or accounts or stock accounts, held like this, the survivor automatically gets it. We're not recommending it, but it's a way, we'll see why, but it is a way to avoid probate. So if you and your spouse own real estate as community property with right of survivorship, one of you passes away, the survivor just gets it. No court proceeding or anything. We file some document with the recorder, and that's the end of it. Another thing is called payable on death accounts. You may have the CD, may not have a lot of assets at the time. You've got a CD, you've got some savings accounts. You can actually set those up as payable on death. So if you've got $25,000, $50,000 in some sort of a stock account or a savings account, you could say payable to my children on my death. They bring in a death certificate and the bank just cuts them checks. So that's easy, but it's fine for smaller estates, and it avoids the cost of probate and even much estate planning. Life insurance, great. It has a named beneficiary. So things that have named beneficiaries go according to the contract. So life insurance is good. If you've got minor children, you don't want them named as beneficiaries of life insurance because they're too young, they can't get it. The court's going to require a guardian, more court process. So that would be the beneficiary of a life insurance policy can be your trust, for example, and that can be used to help the children until certain ages. Same with retirement plans. They have a beneficiary. You name your spouse gets to roll it over to their own IRA. You can name your kids, they can stretch out the payments for a while, but there's some planning. If they're minors, again, you can't leave them the retirement plan. And the living trust. And that's one of the things we're going to be talking a lot about, the living trust. So one, is joint tenancy a good idea? You know, a number of people come to me and they say, you know, I've got a couple of kids. I basically own this house, which may be easily worth $1 million if you're in Ventura or something like that. And I'm just going to put my 2 kids on as joint tenancy and not worry about it. Well, advantages. It does avoid probate. There's a right of survivorship. It's not probated. The survivor just gets it. It can avoid creditors of the deceased joint tenants. So let's say you're in joint tenants with a sister or brother or somebody, and there's creditors after them. They die. You get the property free of their creditors. You just get it. They have no claims. It's easy and inexpensive, very simple to set up. Most type of assets can be owned that way. Houses, bank accounts, your cars, easy. Married couples should consider holding non-trust real estate in the form of community property with right of survivorship. The reason you want to hold community property for spouses is for tax benefits. Community properties, and there's only like 12 community property states in the nation, but the IRS has given a special break for community property, that if one spouse dies, there is a 100% step up in basis. And suppose you paid $100,000 for a piece of property and now it's worth $1 million. If one spouse passes away and you hold it in community property, then the survivor spouse gets it with a basis of $1 million. Which means they pretend it cost $1 million, and that's what they paid. And then if you sell it, it's income tax free. So community property is a better way to hold things if you're concerned about that step up and avoiding capital gains on properties. Okay, if your joint tenant is your spouse, okay, if it's joint tenancy, your spouse's interest will not receive a step up in basis. So only half of it gets stuck. So if it's $1 million now and you paid $100,000 for it, only half of it will get stepped up to today's value, $500,000, and the other $500,000 will be subject to capital gains. So you definitely want community property. If you need more explanation about that, come see me. I could explain that, or you could email me. But just keep in mind that for spouses, community property is much better than joint tenancy. If your spouse, okay, also, joint tenancy is incompatible with estate planning, estate tax planning. You've got lots of property in joint tenancy, you pass away, your spouse just gets it all. There's no opportunity to plan, no opportunity to try to reduce the estate tax. Your surviving spouse just gets it all. Now it's in his or her estate, and it could create problems later on. And it could cause the estate to increase to the estate tax level. Not likely today because it's so high, but it is going to come down, and we'll see what happens. It just becomes your, property on death. Okay, disadvantages, especially if someone's not your spouse, you can't control disposition at death. So, if you're a joint tenant with somebody who's not your spouse and you pass away, they get it. It could be a brother, sister, a friend. Maybe you have some sort of understanding that you'll share it with their kids or whatever. No, you have no control. You pass away and your friend or your other relative just gets it. Also, if you create a joint tenancy, people don't really realize this. You've got this $1 million property, you want to put your kid on as a joint tenant, let's say, you just made a $500,000 gift and you have to prepare and file a gift tax return. No gift tax will be due, but a gift tax return, and it could have effect later down the line. Also, if you're a joint tenant with someone, they may transfer their interest to somebody else, to either a boyfriend, a girlfriend, a spouse. They could sell their interest, and now you own this with strangers. And it's not a good idea to own it with your kids. And I'll tell you the main reason is, you have a couple of children, and you want to put them on as joint tenants, so there's no hassle. They just get it on your death. They may be the best kids in the world, but they may get into an accident one day, take out a school bus, get a $10 million judgment against them. You will lose your house. the creditors will come and take the house, or they don't pay their income taxes. Too much of a risk for parents to put on joint tenants with the kids. Plus, the kids won't get this entire step up in basis, where if they just inherit the property that you paid $100,000 for and now it's worth $1 million, they inherit it, and the IRS pretend they paid $1 million for it, they can sell it tax-free. They don't get those same benefits if you put them on your property as joint tenant. So it's better to leave it to them in a trust than putting them on as joint tenants, even if that's really basically most of your estate. Okay, and if you have somebody as a joint tenant on your bank account, not your spouse, they can take the money. Again, their creditors can take it, but they, just giving somebody the keys to the vault, they can just take the money. And that's always a concern, or their creditors can get it. All right, so here's how you can avoid probate. The best way to avoid probate are assets transferred to a trust during your life are not part of your probate estate. And you want to make sure that if you have a title policy on your property, that it also would cover your trust. Most people can't find their title policies after so many years. New title policies in the last 10 or 15 years all automatically cover your trust. But old title policies, you may need to get an endorsement so that if there's ever a claim on the title, now it's owned by the trust, the insurance will cover it. Trusts provide the maximum flexibility for distribution. Joint tenancy doesn't. Joint tenancy, you pass away, the survivor gets it. No flexibility. Trusts provide a lot of flexibility. Okay, so there's also, this is interesting, a new thing, fairly new, called a transfer on death deed. You know, I told you we had payable on death bank accounts. Well, if you have certain kind of properties, 1 to 4 units, condominium unit, some agricultural property, you can file a deed with this county, a special deed with the recorder, naming beneficiaries. So you can name them there. So you put your kids on as beneficiaries on your death, they get it. And they've inherited it, and they get the step up in basis, and their creditors don't have it. They have no interest while you're alive. So it's kind of cool. Unfortunately, few title companies are willing to issue title policies on those kind of death deeds, but there's something to think about. But you know, you could change your mind. It's difficult, but it's something that's fairly new, something to think about. If really your main asset is a piece of real estate, you could do this payable on death deed, which could give good tax benefits, no risk while you're alive, and easy for the beneficiary. Okay, trusts. Okay, so trusts can do all these things. They can provide for incapacity during your life. Now, I talked about power of attorney. So power of attorney and trust can do a lot of similar things. When you have a trust, you're a trustee. If you can't handle your affairs because you're incapacitated, they have everything in the trust. They deal with the real estate, they deal with insurance, they deal with the bank accounts in the trust, the investments in the trust, but there's certain things of power that a trustee doesn't have authority to do. That's why you need both the power of attorney and the trust. Trustees can't deal with retirement plans, Social Security, taxes, litigation. They can't deal with that. That's when you need your agent under the power of attorney. So often they're the same people and they work hand in hand. But so the trust helps you during incapacity. You don't need a conservator. The trustee just steps in. What happens to your estate at death? Who gets what, when, and where, and how? Manage the estate after death, because sometimes you have minor children, somebody who can't handle money yet. Somebody has to manage this. Family dynamics, we'll talk about that. Trusts avoid probates. Remember how expensive probate is? Also, trusts are private. No one knows. It's private. The trustee gathers up the assets, pays the debts, and essentially hands out the assets. And it's all done very quietly and privately. And you can minimize and eliminate the estate taxes with a trust. And here's how it works. Really isn't that complicated if you can visualize it. The person who sets up the trust is called the trustor, or sometimes a settlor. But here's trustor, and that's you. Here's all your assets. And you transfer it to yourself as trustee. So you actually are both. You're the trustor and you're the trustee. And trustee, you hold and administer distribute these assets for your benefit. You get all the rights, you get to do whatever you want with it, and on your death, whoever is the new trustee pays it off to these beneficiaries. It's smoke and mirrors, kind of, but it really works. You transfer it to yourself, and while you're alive and well, this trust is not a separate entity. It's not a tax-paying entity. It's not an asset protection entity. It essentially is just to avoid probates and conservatorships and make transferring assets easy. And you answer to nobody. You can change it, do whatever you want. But eventually, it'll be gone to the beneficiaries. So there's a different couple kinds of trusts. One is the inter vivos or living trust. That's the one we're most aware of and common. It's effective immediately. As soon as you do your trust, you put some money in it, it's effective. And it can handle those assets and help you. A testamentary trust is created by the will, requires a probate, and only becomes effective at the end of probate. So there's really no point to testamentary trust because it doesn't help you while you're alive as far as conservatorships are concerned. And you got to go through the whole probate process and then set up the trust. So it's not recommended. The living trust is what people do. Revocable trust. That's kind of most living trusts, family trusts, they're revocable. That means the trustors can amend it, revoke it anytime before death. You can create it and life changes. 5 years, 10 years, 15 years, whatever later, say, you know what, I'm going to make some changes. Easy to do. There is no tax or asset protection basically during lifetime. Again, it's just a way to avoid all the costs and expenses of probate and conservatorships. We also have irrevocable trusts, used very seldom, sometimes for tax planning, sometimes for asset protection. But once you set up an irrevocable trust, that means it's irrevocable. You can't amend it or revoke it. And it's very hard to know over the next 20 or 30 years whether or not you need to make changes. So it isn't used often, but it's there. When you set one of these up, it's treated for tax purpose as a gift. So you put $1 million in an irrevocable trust, it's like you made a gift, and you'll file a gift tax return for that. But there can be some income tax and asset protection benefits. We could discuss that more if you wanted to, but it's not used very often. So basically the living trust, the irrevocable inter vivos trust, that's the one that most people use. And here's our common trust provisions for married couples with children. Okay, so you got Frank and Sally. Okay, they transfer assets to themselves as co-trustees. So Frank and Sally transfer their real estate, that move their bank accounts over to Frank and Sally as co-trustees. They are also the beneficiaries, so they answer to no one but themselves. If one becomes incapacitated, the other becomes the sole trustee, and just keeps going. If one dies, the survivor is the sole trustee and beneficiary. So if one passes away, the survivor is the trustee, beneficiary, answers to no one. You also want to have what we call a pour over will. You may say, well, why would you need a will if we have a trust? Well, interestingly, the pour over will is a precautionary device. In case you buy something that's not don't put it in your trust. Something that happens sometimes is you may own a piece of property and you want to refinance it. Some banks, many banks, they say, we don't want to loan money to trust. So you got to take it out of the trust, put it in your own names, we'll do the refinance, and then you put it back in the trust. But you forget to do so, and you pass away. Now that property has to be probated, but the pour over will says whatever has to be probated, pour it over into the trust. So it just goes from the court to the trust. And if everything is in the trust, everything above $166,000, you don't never use it. This is just basically thrown away, but it's there as a precaution, something to have. Okay, so when the survivor dies, and we had Frank and Sally, when the survivor dies, there is a successor trustee. They take over. This is the whole thing about family dynamics and who should be the successor trustee. We'll get into that, but that's a big issue. And the successor trustee takes over. They gather up the assets, they pay off stuff. If you haven't designated who gets what personal property, the trustee decides who gets the painting, who gets the cello, whatever it is. And then the descendants, the children, they become the beneficiaries. And the trust can direct the successor trustee to distribute specific items, if you've thought about it. Again, the musical instruments to Sally or to Mary, and the fishing stuff, and to the vacation home to these people. Be very specific. And then you divide it into shares for the named beneficiaries. That's what the trustee does. So successor trustee has a big responsibility, but they work with the lawyers and accountants if necessary, and it really is not bad. So by holding trust for a younger beneficiary, because you might have, sometimes people have little kids and they still want to do a trust. We normally do not recommend giving them the money at 18, as I talked about. But while they're kids, the trustee uses the funds in their trust for their support, education, medical care, just like you would. So they have that kind of responsibility. It should be somebody, hopefully, that you could trust, and that the kid needs things, they just take care of the kid. And then when a kid turns a certain age, you start giving out the money. Again, give it all at 18, they will be broke very quickly. So I usually recommend, if it's a side, even if it's like $500,000, you would say, okay, we'll give maybe a third when the kid's 22. He'll spend it by 23, he'll be gone. Maybe we'll give half of what's left at 26. Maybe they'll spend it, maybe, probably. I'll give the balance when they're 30. And hopefully by the time they're 30, they will know better and they'll hang on to it and invest it wisely. Some parents say, I don't want my kid to get at least 50. I don't recommend that, because then your children will hate you until they're 50. We don't recommend that, but it's all very personal and specific. You've got to, but those are issues, big issues to think about. Even small amounts of money, with where we have life insurance and pensions and house values, it's just, it's sizable, even small. So it's important. Other benefits of living trust. You can protect children from prior marriages. We'll talk about how you do that. You've got kids and your spouse has kids. Well, things are happy, hunky-dory, and you just agree that, we'll just divide everything. When the second one dies, whatever's left is divided among your kids and my kids. That's all well and good, except that if it's 20 years later, the surviving spouse may or may not even know your kids, and they're not going to get it. So, but it depends on how long you've been married and a lot of situations. But with a trust, you actually can protect your children. We'll see about that. There can be some asset protection. There can be some estate tax savings, which we'll see. Okay, so here's a trust that's a little more sizable that we want to think about. So here's what you can do: protect children in prior marriage, asset protection, estate tax. And how you do this is you can actually create your trust, which is, we just share everything. It's just life goes on like you don't have a trust. The husband and wives, they share, they answer to nobody, they make changes. There's no tax issues, there's no asset issues, nothing. And then you can create, on the death of the first spouse, you can then divide the estate basically in half. And you could put the survivor's half essentially in what we call Trust A, which is the survivor's trust. And the survivor can give that money to the next gigolo, next bimbo, whatever they want, to gamble it away, whatever they want, it's their money. The other half, let's say your half, and you pass away first, you put in a special B trust, special trust. It becomes irrevocable. It has certain names: decedent's trust, bypass, different names. The thing about that's interesting is the surviving spouse can get all the income, okay? And the surviving spouse can be the trustee of this trust, gets all the income, principal if he or she needs it. But on the surviving spouse's death, this money in the B trust will go to where you've designated it. So if you have children from a prior marriage, you can be guaranteed your children will get your half, or what's left from your half, out of the B trust. The other advantage is the spouse's creditors can't get it. Assets in the B trust is protected from the surviving spouse's creditors. So if the surviving spouse gets in the debt, gets problems, the B trust does not have to deal with the creditors, can buy things for the surviving spouse, and they're protected. And also for estate tax purposes, if the spouse just got it all, it may be so large, the estate, that there could be an estate tax. This way you divide it in half, the amount in the B trust will never be taxed. It could go to $100 million and it'll never be taxed. So there are advantages to doing this. It's more complex, more costly. Separate tax returns have to be filed, separate accounting, so you got to keep good records. But if you have a large enough estate, are you really concerned about protecting your kids from prior marriage? You're concerned your spouse may not do that for your kids. This is something to consider. Again, it's the kind of stuff you talk about. That's kind of cool. And you can actually set this up so that the surviving spouse can decide to do these trusts after the first person dies. You don't have to automatically require it in your trust. Because you don't know what the estate tax is going to be. You don't know what the creditor situation is going to be. So you can actually set this up that the survivor can decide to create these two trusts after the first person dies. Or you can make it mandatory in your trust. A lot of planning and thought can go into this. Kind of cool. So a probate avoidance trust. Most people today, we'll see why, aren't concerned about estate taxes. But so it's mostly a probate avoidance. So you save all the probate fees. There's no tax planning, but you still can do the AB trust and protect children from prior marriages. You can do that. So let's look at a simple situation. Here's Matt and Kim. They got a house with $650,000 equity. They got a bank account with $60,000, life insurance for $100,000. They got $810,000. Okay. If they just passed away, the probate fees would be $38,000. But here's the trust. Matt and Kim, they got a son, and a daughter, and they got some grandkids. Very kind of typical family situation. So Matt and Kim have $810,000 worth of stuff. They transfer to themselves. Matt and Kim, Matt and Kim. And they hold and administer for the benefit of the beneficiaries. But meanwhile, they answer to no one. They spend the money the way they want. They live like their lives. Then you've got Matt dies. There's no probate. Kim just steps in. Kim's living. Then the son dies. So often the way it is you got Matt and Kim. Matt dies. Kim then takes over, gets all the income, all the principal. She can do whatever she wants with that money. And then the goal would be, I leave it to my 3 children. But if one of your children predeceased you, then maybe, usually the way it goes is to their children. Usually it's the issue. If you have a deceased child who leaves children, they get it, as opposed to the other 2. So these 2 grandchildren each get a 6th, and each son gets a 3rd and daughter gets a 3rd. And they get it outright because they're adults, and the grandchildren are minors, so it maybe stays in trust until they're 25 or some age for the minor grandchildren. And that's how it works. It really is for Matt and Kim, it's pretty simple. Okay, now this is the issue on family dynamics, which can be fascinating. Vulnerable family relationships. Obviously, parents and adult children. So if you deal with your parents and you have adult children, vulnerable. Step-parents and stepchildren, adult stepchildren, siblings, everybody you can think of as vulnerable family relationships. The value of family harmony. Most estate planning clients, actually, if you talk to them, they place a higher value on the preserving family harmony than on who gets what of the worldly possessions. And studies have shown over and over again, and our experience has shown it, if you leave assets unequally, even with good reason, like I've given my daughter hundreds of thousands of dollars during her lifetime, my son never asked for a penny, you get good reasons. Or it's going to create this bad taste in everybody's mouth, the beneficiaries, and it may cause strife forever in the family. You may know situations like that. So it's a big deal not to leave equally. We've seen situations where some children have been extremely wealthy and others, school teachers in the inner city schools, if you don't leave everything equally, there's family strife. It's just the way it is. So the question is, who's going to be a financial fiduciary? So if you and your spouse can no longer be the trustees because you're incapacitated, you pass away, who's going to do it? And they usually fail to underestimate the risk of family harmony by naming a child or children. That is an issue. Appointing all the children, especially if there's more than 2, can create opportunities for disagreements. And if you have 3 kids and you name them all the trustee and 2 agree and 1 doesn't, the one who doesn't is going to feel picked on, and it's going to be just very, fractional. It's going to be tough. Independent third-party trustees, you can eliminate a lot of heartache by having independent trustees, if you can, to think about. Bank, trust companies, and there's also now private fiduciaries. And they charge, but at least you know that's just going to be, there's not going to be big disagreements. Right now, if you have 4 or 5 children and you name one of them as trustees, the others, this is the way it is. If that trustee child doesn't distribute all the money in like a week, the others are convinced he or she is stealing. And they're going to want to know, where's the money? What are you doing with it? It's been a month. I haven't got my money yet. What's the deal? So if you have a private fiduciary or a bank, not going to have that issue. Also, naming really bad if you have a kid, one of your children, be trustee for the other child, big issue. So you've got a 25-year-old and a 15-year-old, and you say the 25-year-old will be trustee of the 15-year-old until he or she is 25. Awful, because that 15-year-old is going to have to go into his older brother or sister and say, I need money. I'm not saying I need money. I want money. I need to get a car. I want to go this. I want to go here. Give me money. It's also a problem if you name your sister or brother trustee of your minor children. They got to be prepared to know that those kids may very well be calling them every other day asking for money. It's just how it is. And eventually these relatives, aunts and uncles, they just give up, give the kids whatever they want. It's too much. You have a bank or a private fiduciary, kids can cry all day long and they're not going to care. They'll decide how much to get and take care of them. So this is a big issue, something we really need to talk about. Some families are great. You've got a couple of kids, they get along, they're both financially savvy. Sure, they can be the trustees, they're getting equally. Also, the trustee decides how to distribute stuff. So you've got an estate, some real estate. The trustee could say, one of the kids is a trustee, can say, well, I think I'll take the vacant lot on Wilshire Boulevard, and I think I'll give my sister the house in Peru. Yeah, it's not good, right? So these are kind of issues that you got to deal with. Family dynamics, huge. Yeah, we have a whole program on family dynamics too, but we'll go on. The federal estate tax. We'll see why it doesn't concern most people right now. Right now in 2022, you have to have more than 12,060,000 or 24,120,000 for a couple before there's an estate tax. Okay, so I'm sure none of us here, including me, are going to pay an estate tax based on these numbers. But this is based on the Trump tax cuts that they happened in 2017, and this whole exemption of this amount is repealed. It disappears in 2025, and it goes back to the 2017 levels, which would be about 6 million. Still a substantial sum of money, but it's not the same. But depending on what the future brings, because we don't know, if the Democrats should get in charge, truly in charge, they would like to make the estate tax level above 3 million. So anything above 3 million is taxed. If the Republicans get really in charge, they probably do away with the estate tax altogether. So we don't know. So we have to plan for the possibility that something could happen regarding the estate tax. So we do that within our trust. Gifts, right now you can make a $15,000 per donee gift with no gift tax consequences, no filings. What does that mean? Husband and wife could give $30,000 a year to each kid or each donee, no tax, no filings. But people don't really realize that. I mean, a parent might buy their kids a $35,000 car. They're supposed to file a gift tax return because it's more than $30,000 for a couple, for one kid. But that's $15,000, so it's something. Now, anything over the exempt, and same for gifts. Once you've given $24,120,000, you pay gift tax if you're a couple. And the tax, estate tax and gift tax is 40%. So yeah, $30 million, everything, 6 million would be subject to 40% tax. And we have something now. One of the things that we used to use is these A-B trusts I talked about, where half goes in the B trust, half goes in the A trust. Suppose you have a $20 million between a husband and wife. Well, if one just passes away and now the spouse has 20 million, there'll be a tax because it's more than 12 million. So you create this A-B trust where 10 million is in the A trust, 10 million in the B trust. The B trust never gets taxed. The spouse only has 10 million, dies, no tax. Now we have something called portability, which is something you can do instead of creating these AB trusts. Because the AB trust is more complicated, tax returns. It's a special thing you do. You file with the IRS on the death of one, and the surviving spouse just gets to use the deceased spouse's exemption amount. Sounds complicated, really not all that complicated, but it's just ways of dealing with it. In the last few years, quite frankly, we haven't dealt with many people that truly had estate tax situations, although they do. I mean, there's plenty of people with 30, 40, $50 million, and you have to deal with it. But for most of us, we have to wait till it changes before we're that concerned. Okay, now you may be familiar with Proposition 19. That was a big deal. A lot of calls on that when that happened. Remember the old Proposition 13, where a parent could leave its principal residence to their child, regardless of its value, and the child will inherit the tax base. So if a parent bought a piece of property for $200,000 and was paying $3,000 years for taxes, and now the property is $2 million, the kid will inherit it and only pay $2,000 a year for property taxes. You get to take it with you. At the special form you file, and you get the inherit your parents' property. If it's other than the personal residence, you get up to $1 million in assessed value. And the assessed value is the value shown on the property tax. The assessed value is not the same as fair market value. So rentals and other properties up to $1 million of assessed value, and you just carry your parents' same property tax with the annual 2% inflation that we all get. It's a simple matter. Okay. Also, under formal Proposition 60, if you were a homeowner or a spouse who's at least 55 or disabled, you could sell your residence and transfer your property tax base to a replacement residence of equal or lesser value. Many people have done that, right? They become 60, 65, they've got a house that's too big, the kids moved out, they want to downsize, they could sell the house. You know, they paid $200,000 for it, so they paid $2,000 or so a year in property tax. Now it's worth $1 million. They could sell it, buy something for $800,000. Well, instead of paying $8,000 in taxes, they could carry over their $2,000 to buy a house of lesser value, and you can only do once in your lifetime. And basically, it has to be within the same county. Okay, so it's the transfer. You could do it in different counties. There's only a few counties that would do that. There had to be inter-county agreements. And Ventura County was one of them. You could transfer to other counties. Complicated. You can only use it once, and you can only use a house of lesser value. Changed. Okay. Now you can transfer property tax in all the counties, and you can do it up to 3 times in your lifetime. Previous law was just once in your lifetime, and you can do it again. So now again, you have a very valuable property, but a low tax base. You can buy a property of the same or lesser value and keep your same low tax base. If the home is of greater value, then the excess amount is subject to the property tax increase. Okay, so now the county will increase if you leave property to children and they don't use it as their principal residence, they're taxed at the fair market value. The parents can no longer just pass on the property tax base. So again, you paid the $200,000, now it's worth $1 million. Your house, you leave it to your kids. If none of your kids live in that house, they're going to pay property tax as if it was $1 million. If the child inherits the property and moves in as his or her primary home, there is a benefit. They take the parent's property tax base plus $1 million of fair market value before there's any increase in property tax. So let's see. You have a $2 million home that has a tax assessed value of $500,000. Okay, the child lives in the home. So the first $1.5 million, because there's assessed value of $500,000, you inherit that, plus another $1 million of fair market value. It's taxed the same as the parents. But the next $500,000 is taxed at fair market value. May seem fair, but the property tax is just doubled, which is obviously a problem. Okay, also other property, this is interesting. If it's not principal residence and a kid isn't going to move in there and live in there, it's just rentals you have, it's all taxed at the fair market value. And there's no inheriting a parent's property tax. And this was done for a very good reason, because there were premium properties, especially in like Malibu area, that people bought in the 70s and early 80s that are worth 20 times what they paid. You know, kids are inheriting, probably parents paid $2 million in the 70s was a lot of money, but now the house is worth, $25 million. Well, they would inherit that. They'd pay the property tax based on the lower value, and they'd rent it out for $30,000 a month. They were just making money hand over fist. So the government decided that's not fair. If you inherit those kinds of premium properties with a low tax base, it's just going to be up to the current property tax value, fair market value. And, most kids couldn't pay, even if getting $25,000 a month in rent, hard to pay property tax 20 times what it was when your parents were alive. So that's important to know about transferring property. There's going to be the property tax basis, which is good for realtors because kids would just hang on to the properties because they had a low tax base, they could rent them out, but now the property tax will go up so much, and the kids might decide to sell it, which is good for the economy and the real estate market. Okay, so good. We didn't really spend much more than an hour, so that's great. So at this point, we'll see if there are any questions, and Gabby can kind of summarize them, and we can see if we can address the questions for you guys.
So there was one question that just came in right now as you were going through that. And they asked, can my parents' Proposition 13 be transferred upon inheritance? Is this what Prop 19 does for me?
It depends. Again, if your parents pass the property on to you and you live in it, it's going to be your residence, then you get to carry your parents' property tax base, whatever's on their property tax bill, plus $1 million of fair market value. So unless it's worth substantial, more than $1.5 million, essentially, or $1 million plus the assessed value, you're going to take on their property tax. That make sense?
I think it made sense to me. So hopefully, if that
Okay.
response, if you're still a little confused on that Prop 13, Prop 19, definitely want to dig a little bit more with an attorney.
Just shoot me an email or whatever, and I'll be glad to answer it. It's a formula, but if it's, your parents are a property tax base of 200,000 and the house is worth less than $1.2 million, you will take on your properties, your same tax base that your parents had.
Yes. Okay. The other question was, when creating a trust, do we need to go and show proof of it to our banks to change ownership of accounts?
Very good question. Actually, I probably should have addressed that. When you set up your trust, it has stuff in there. It has personal information about your family. So we've also prepared something called a certificate of trust. And it's a special document that has only the language that they need. And you show that to your bank, your investment company, and they then will set up the trust. What's interesting at banks is your checks don't change, your check account number doesn't change, your checks don't say trust on it because the people at bonds won't know what that means. They just internally know that it's now owned by a trust. And you give them the certificate of trust, they take care of it, and then it's in trust. So it's a good question.
Good, definitely a good question. The next question that came in early on, and there's actually two similar questions. I'll ask the first one. Who can ask us for a copy of the trust?
While you are both alive, one of you, as long as one of you is alive, no one can ask for a copy of the trust. You have to share it with no one, and that's a good question too. Obviously, if you become incapacitated, the person who you named as successor trustee gets a copy, but no one gets to see it. So one question that a lot of families have, and it's again individually, some parents, they don't want to share what they own. They don't want to say what they have. They don't want to say who gets what. They don't want to discuss it with their kids, and their kids can never see the trustee passed away. Other families say, you know what, I'm going to create the trust, and I'm going to sit down, and I'm going to tell my kids exactly what it is, so they all know, and if there's questions, we can deal with it now. So that's also a good question.
So the other similar question that came up was, if we're changing ownership, who do we present proof of trust to? So I'm assuming this person might be inheriting, and then who do they present that proof to?
Very interesting. It's a process called trust administration. So if somebody had a trust and they pass away, the trustee will prepare a deed. Well, one of the things they do is something we record called an affidavit death of trustee. So if the trustee passes away, because the house might be in Sam Smith, trustee of the Sam Smith Trust, he passes away. Title companies are going to want to see Sam Smith sign it, the deed. So you prepare an affidavit death of trustee, record it, and you say who the new trustee is. And then that new trustee just prepares a deed and signs the deed over to the beneficiary, and the beneficiary now has title to the property. No one ever has to see the trust.
From the trustee. So actually a question that came to mind right now as you were explaining that process is who helps the new trustee do all that paperwork?
Generally, it's everything is so complicated nowadays. You really can't do it all yourself. So you go to your lawyer, whoever helped prepare the trust, and one of the things that they do is trust administration. And we can talk quickly about cost and price. Nobody asked. Usually that's one of the first questions. But it's hard to know. That's why we have this estate planning questionnaire that we have people fill out, and we meet with them, and we decide what's best and what it might cost. But as a rule of thumb, for a couple, you're looking between $2,400 and $3,500. That's the range. Could be a little less, could be a little more. And that includes transferring a business, transferring some real estate over. Trust administration, and that's fixed, fee. The only additional cost would be recording charges of deeds. Trust administration is hourly, and they can run, $2,000, $3,000 up to $5,000, still substantially less than any probate fees. But it's, again, clearing the titles to the real estate and making sure you send out special notices, protect the trustees so they won't be sued. There's some steps to go through. But it's the law firm who helped you with the trust, or any law firm that does this can help do that.
So actually there was a question that came up about the cost to creating a trust. So you said about 24 to 3,400.
Yeah, between 24 and 3,500. Yeah, it's like that. Could be less, could be more, but that's a range if people want to do it. Now, don't do it yourself. Don't go on LegalZoom. We've seen so many messes on things like that because, gee, you pay so much on LegalZoom and you get all these choices. And so you say, well, I'll just choose them all. Same price. Well, you just screwed the whole thing up because you can't choose them all. So yeah, it's just best to pay for a good legal representation. And
sounds enticing. I know.
Yeah.
But you want to go with an expert to sit with you personally and go through all that stuff.
Well, because it's much better. Also, we usually recommend that our lawyers would keep the original estate planning documents, because one, people can lose them, or they get mad and they say, I'm going to go take Mary out, and they cross out on the trust. Well, they just damage the whole document. So we usually give copies, and we keep originals in our vaults, so they're always safe and sound, and you can't mess them up by writing on them.
Good to know that. Don't write on your trust, guys. How complicated it is to change title?
Well, if it's real estate, it's a deed. It's a deed. So it's very simple. If it's a husband and wife, and I'd say it's not community property, there'll be two deeds. We do a deed to husband and wife community property to make sure it's community property to get that big step up. And then it's a deed to the trust. It's a couple of deeds. So you're talking, $400 on recording charges or something like that. Not a big deal.
So not a very extensive process, something that can be done though.
Yeah. Don't try to do it yourself. It's just not worth it. It's too easy to mess up. And the sad thing is, if you try to do things yourself, you don't know you messed up until it's too late.
So this next question that came in is good. I don't own a home yet, but I would like to create a trust. When I purchase a home, how will the trust work then?
Okay, the goal again is individual with your bank and finance company, but those banks and mortgage companies that are into the 21st century, they will say that's fine. We will loan the money, and and if you have a trust, you will buy the property in the name of the trust. The bank loan will be in the name of the trust. You personally will guarantee it, perhaps, but you'll just buy it in the name of the trust. If the bank says no, we got a loan to you personally, then you buy the house in your name and you come see a lawyer, and they just transfer it into the trust. So the trust is already there. You don't have to make any changes to the trust if you're happy with the way it's set up, and the house just becomes part of the trust assets.
So definitely ask your loan officer, make sure if there's any limitations with having a trust and purchasing the home through the trust first, or as Roy said, doing the transfer of names later.
Right,
Um,
right.
Medically, how can I prove that I am mentally capable to make living trust decisions?
Well, that you don't have to prove that you're mentally capable. Somebody who is contesting your right to do that would have to prove you're not mentally capable. You don't have to prove you're mentally capable unless someone's trying to get a conservatorship over you and you're fighting that. But yes, and how it works is the lawyer's going to meet with you and talk to you. The lawyer will sense that you have capacity and competent. If the lawyer feels you're not, they won't prepare the trust. So they prepare the trust if they think you're competent, which is easy, and there's a notary that also looks at you and talks to you and notarizes. So you don't have to prove that you're competent. People will talk to you, and somebody contesting this would have to prove you don't have capacity.
So if someone's having medical difficulties now, but the attorney knows that they're competent to make these changes, they can sit with an attorney to make those decisions on the trust.
Absolutely. Now, people sometimes are very ill. And you don't have to have a whole lot of capacity to know what you own and what you want to do with it. As long as you know basically who the natural objects of your bounty are, and that you're doing a trust or your power of attorney, that's all you have to really know. But the attorneys will talk to you and make sure that you're competent. But people can be very ill. We, go into hospitals all the time sometimes and have them do the trust at that point, make sure they're not too medicated, they know what they're doing. We talk to them. Yeah, so it's done. Yeah, you can do it.
So this next one is, if I have a power of attorney now, will the trust power of attorney precede that one?
Well, there is a trust, and the power of attorney is a separate document. So if you're happy with the power of attorney you have now, nothing can change. The trust won't affect it or change it. If not, then you do a new power of attorney and the old one goes away. So the trust, generally the successor trustee and the agent and the power of attorney are often the same people, but the trust doesn't supersede your power of attorney. That's another separate document.
Separate documents happening there.
Yeah.
This one's a different, I haven't heard this question before, but do I have to hire an attorney in my county to create my trust?
No, you don't. It's a good idea to hire an attorney in your state because state laws are different. And trusts, by the way, are good in every state. So if you do the California trust and you move to Nevada, it's good in Nevada. But you definitely want to have, whatever state you're in, a lawyer there. You do not need a lawyer in your county, although you're going to have to see the lawyer, or he's going to have to come to your house, because you're going to want to have to go through the documents with them, and you're going to have it notarized, and you can take the stuff to a notary yourself, but you might miss something. But it's just a matter of convenience, but there's no requirement that they be in the same county.
That's a good question. Hadn't heard that one come up before.
Yeah, it's interesting.
So this next question is, if there's changes to the trust, where or how do we record them?
Okay, so keep in mind, trusts aren't recorded. They're private, they're kept secret. If there's a change, you can do a couple things. One, you can do an amendment, where you go see the lawyer again, and they just do an amendment to the trust. We'll take out section 6 and put in a new section, take out Mary and put in Sam, make amendments, change the trustee. Oftentimes, however, if you're going to make a major change, we recommend doing what's called a restated trust. We just restate the whole thing. So the old trust, no one ever sees it all ever. Because maybe you don't want Sam to know that he was once in the trust, now taken out. So but it's basically, if it's a simple change, an amount, or you want to change the trustee, it's a simple amendment.
Good. And so on one of the slides you were showing, going back to the question of cost that just came up again, the question was, how much is probate versus a trust? As you showed, probate is usually a percentage.
It's a percentage. So the thing I showed of, I think it was the $800,000 estate, the probate fee was about $35,000, $36,000. Where if they did a trust, and plus you still got to pay for if there's a will, you got to pay for the will. But just the probate was like $35,000. A trust administration would be, 2 to 3, no more than 5,000, and you'll spend maybe 3,000 to set it up. So it's still much cheaper than a probate, and it's quick, and it's seamless, and it's private, and you still got to pay to have a will done. But yes, it is considerably less expensive to do a trust.
Definitely significantly less on that regard.
Yeah, it's less for your kids or your family, not not you because you're gone. But overall, it is just much less. And also, you just saved your children or your loved ones a whole lot of hassle of having to deal with the courts.
Exactly. A big, big problem there that can come up.
Yeah.
So actually, those are all the questions I have so far that came in. I am going to share actually my slide here to show for anyone wanting. I know, Roy, you were sharing your slide there with your contact information, but I have it here again. And I also have the website at the bottom, which I'm going to put in the chat in a second. So if you'd like to sign up for the newsletter that Roy's office has.
The
So
newsletter is great. That covers all kinds of things, not just estate planning, business things, tax changes, real estate changes. It's interesting articles that come out every month or so.
And they really are. I get them myself, and I actually spent some time reading it when they come out.
Well, good.
So thank you, thank you. So those are all the questions we have so far. I'm going to be sharing your contact details through the chat as well. So if in case someone finds it easier to copy and paste here. But thank you so much, Roy, for sharing this information, vital information. Again, like I mentioned at the beginning, anyone can start thinking about this. You don't have to be a homeowner. You don't have to be older. You can think of this now. So this is obviously a really great time to put to work your tax refunds.
Yes, well, thank you very much, Gabby. Appreciate it. And thank you, everybody, for joining. And just, feel free to email or whatever if you have questions, and we'll try to answer them for you.
Thank you so much, Roy, for joining us. Hopefully, you enjoy the rest of the night. For all of you joining us, thank you so much for joining. And hopefully, again, the information here will serve to enlighten the process of having a will and trust and which one is the one that best meets your needs. So, thank you all. Thank you, Roy. Hopefully, you
Okay.
all enjoy the rest of your night.
Okay. Bye bye.
Bye. Thank you.